Well, good morning and welcome to today's virtual discussion on federal, state, and COVID-related leave laws. I'm Jennifer Sims with the Capital Region Chamber, and thanks for joining us. I'd like to thank both Rose and Aaron for their time in providing us with some valuable updates. Before we get started, I wanted to share some Zoom housekeeping. For viewing this morning's program, it would be helpful if you select speaker view from the top right of your screen. All participants are on mute, and we ask that you keep your mics muted to eliminate any background noise. We're going to start with a presentation from Aaron and then go directly into Rose's, and then we'll have a Q&A session. So if you have any questions, please put them in the chat, which is at the bottom of your screen. Today's presentation will be sent to you later this afternoon, along with the recording. Now it's my pleasure to introduce our presenters. Rose Miller is the owner and president of Pinnacle Human Resources, a WBE for over 10 years. Rose helps clients focus on their business by offering customized solutions for any size company. Rose and team provide needed HR advice, HR compliance, training, leave administration services, and employee handbooks. Aaron Callahan joined Whiteman, Osterman, and Hanna in November 2014 and is a partner with the firm's labor and employment law, education and litigation, and appeals practice groups. Ms. Callahan represents employers, both public and private, in matters including federal and state court litigation, administrative proceedings, and alternative dispute proceedings. Additionally, Aaron works with employers on managing the broad array of issues which may arise throughout an individual's course of employment, provides management training, and conducts internal investigations. Welcome, Aaron and Rose.
Hi, good morning. Hi, so we are going to start off by kind of doing a summary of the COVID-19 related leaves. It's never been easy to be an employer in New York State, and that's certainly the case now. New York employers have over 6 statutes and laws that they have to consider when an employee is about to go out on a leave of absence. And there are COVID-specific leaves and non-COVID specific leaves, and we may have some new ones on the horizon, which we'll briefly talk about at the end. So to recap, kind of once upon a time, when an employee was about to go out on leave, employers really worried about three main leaves, right? FMLA for those employers that have over 50 employees, New York State paid family leave, and New York State short-term disability benefits. FMLA is an unpaid leave of absence, and New York State paid family leave and short-term disability provide paid leave to employees. The new kid on the block, something that we would have considered irrespective of COVID, is New York State sick and safe leave. This provides employees with up to either 40 hours or 56 hours, depending on the size of the employer, of paid time off for various reasons outlined in this statute. As to the specific COVID-related leaves, we have FFCRA, which most of you are probably very familiar with at this point in time. It was mandated for 2020. And the last week before 2021, Congress enacted a new guidance that said employers are allowed to voluntarily continue FFCRA benefits through March 31st, 2021. Again, this provides paid time off to employees with maximum caps for payments, and it allows employers to take a payroll tax credit for certain benefits paid out. FFCRA, just a quick summary, there's 2 parts to it. You have emergency paid sick leave. And what this provides employees is up to 80 hours of paid time off at their regular rate of pay, up to a maximum of $511 a day. An employee can get this benefit if they are subject to an order of quarantine or isolation, if they have been advised by a healthcare provider to self-quarantine, or they're experiencing COVID-19 symptoms and are seeking a medical diagnosis. The second reason under the paid sick leave component of the FFCRA is if you need to take care of somebody else who is subject to an order of quarantine or has been advised by a healthcare provider to self-quarantine. Ability, and the other ability for an employee to take time off is if their daycare is closed or their school is closed. This doesn't give employees full benefits, but it provides them with up to 80 hours at 2/3 their rate of pay, up to $200 a day. The second part of FFCRA is an expansion of FMLA. And unlike the emergency paid sick leave, this only applies to your employees who have been with you for 30 days or more. And it gives those employees up to 10 weeks of paid time off at 2/3 their rate of pay to take care of their child because their daycare is closed or their school is closed related to COVID-19 reasons. To be eligible for this leave, an employee can't have already used up their FMLA. So the example that's given by the guidance is that if in the past 12 months, an employee has used 2 weeks of FMLA for their own serious health care or their own serious health reasons, and now they need to take time off because their daycare is closed or their child's school is closed, the time that they previously took under FMLA is deducted from this. We also have the New York State paid COVID leave. I call this the previously forgotten leave because in 2020, the FFCRA was mandated and it provided employees with a greater benefit. So some of us, me in particular, largely forgot about the impact New York State paid leave has on employers. That changed in 2021 when FFCRA became voluntary. And so if an employer didn't elect to continue FFCRA, they now had to abide by the New York State paid sick leave provisions. This isn't voluntary. It does come into play more often now. It doesn't run concurrently with FFCRA. So if an employee already took FFCRA in 2020, they are now eligible for New York State paid COVID leave. There's no maximums, so they just get their regular rate of pay and there's no tax credits. And an employee is eligible for COVID-19 paid sick leave if they themselves are subject to an order of mandatory or precautionary isolation or quarantine. I've outlined here the definitions of what the mandatory isolation and mandatory quarantine and precautionary quarantines are, so you can see how broad they are. And I think when I first looked at these, I thought, oh my gosh, like there are definitely instances in the past 11 months, 10 months that I would have been eligible for one of these. So what does an employee get under New York State paid COVID leave? Well, it depends on how big your workforce is. So smaller employers, they don't have to pay anything out of pocket, but the employee gets the benefit of New York State paid family leave and disability, a combination of them. For employers that have a small workforce, so 10 or less employees, but they have a net annual income of greater than 1 million, they have to provide employees with up to 5 days of paid sick leave per quarantine order. Employers with 11 to 99 employees, it's the same benefit. Large employers, those with 100 or more employees, and public employers have to provide employees with at least 14 days of paid sick leave and job protection during that time period. And when we talk about the 5-day and the 14-day paid sick leave, it's not kind of day for day. It's whatever that employee would have been paid during that time period. An employee is not eligible for these benefits if they can work remotely, right? If they're feeling okay and their job allows them to work remotely. That's true also under the FFCRA. And they're not eligible for these benefits if they have voluntarily traveled outside of New York, Connecticut, Massachusetts, New Jersey, Pennsylvania, and Vermont, the states that border New York, and are therefore subject to kind of the state's order of quarantine. So we all kind of had a grasp on New York State paid leave. And then we had a plot twist about a week and a half ago. And the Department of Labor issued guidance on sick leave. And it had a lot of us scratching our head, and we'll kind of get to why that's the case. But it outlined 4 main points. And the first point was that once an employee goes out on a mandatory or precautionary order of quarantine or isolation, you as the employer don't have to require them to test negative before coming back. We know that some employers may want to do that, but it's not required under the law. If, however, an employee tests positive after the period of isolation ends, they can't return to work, and they're automatically deemed to be subject to another period of quarantine or isolation. And what that means for employers is they get another round, another crack at the COVID-19 paid leave benefits. Point 2 is the same, right? If you have one order of quarantine and then you test positive, second crack, a second either 5 days of paid leave or up to 14 if you're a public employer. The third point is that if you, the employer, require an employee to stay out of work, they're not subject to an order of quarantine or isolation, but you are afraid that they have been exposed to COVID and you don't want them coming back into the workplace, you have to pay them. And you have to pay them at their regular rate of pay until you allow them return to work, or they become subject to an order of quarantine or isolation. That was mind-blowing because nowhere in the statute when this was enacted last March is this contemplated. And quite frankly, point 4, which says that an employee can get up to 3 periods of COVID-19 pay, that wasn't contemplated in the statute either. And so I think there's a lot of questions that are out there about the validity of this and these new guidance. The state does have the authority to issue regulations and guidance with respect to the statute, but it's really unclear where they came up with really what's a new form of paid leave, right? They're not subject to an order. It's just that you want to be safe and you want to make sure that the workplace isn't exposed. And then the three cap. What's also interesting about the 3-period cap is that they only get the second and the third round of paid leave if they test positive. So it has to be more than just an order of quarantine. Again, which you don't have to have COVID to get that order. You just have to be exposed to it. So it's kind of a mind-blowing situation, and nobody really knows how this works and how the Department of Labor is going to enforce this, or how employers are really going to be able to deal with it. So I suspect that there may be some more guidance that's coming out that further explains this. But it is at this point kind of the lay of the land per the Department of Labor. So once we get through an employee's paid time off, the thing that some people forget about is what happens if the employee is still so sick, right, that they can't return to the workforce. We know that COVID has serious impact for some people's health and their condition. And the question is whether you, the employer, can allow them to remain out of work on an unpaid basis, and whether that would be a reasonable consideration. So just when we think that we're done with the paid leave of absence, you should know that you do have an obligation under federal and state law to provide a reasonable accommodation to employees that have a disability. And New York State's definition of disability is broad enough, right, where it would consider serious health implications caused by COVID to be disabilities. So kind of what's on the horizon? Well, I talked about how there's likely going to be more guidance, not new guidance, but more guidance from the Department of Labor about COVID-19 leave. We also know that the governor a few weeks ago in his budget proposal floated the idea of paid time off for up to 4 hours for an employee to go out and get vaccinated, 2 shots of vaccine. And so we'll know more about that, in the forthcoming weeks. And then if the budget is ultimately passed, that is something that employers would have to provide to their employees. If anybody's been watching the news, we do know that there also is going to be a COVID relief bill that's coming from the federal government. And there are talks about an expansion of FFCRA benefits, so allowing more workers to be eligible for those benefits and an increase in those benefits as well. So I thought this would be helpful just to share. When I get a call from somebody talking about an employee needing to be out of work, this is kind of the internal map of my mind. So the first question I always ask is, can the employee work remotely? One, are they physically able to work remotely? Are they feeling okay? And two, does their job allow it? Because if the answer is yes, then they're not entitled to FFCRA or New York State COVID leave. It's easy, right? You just have them work from home. If the answer to that is no, then you have to ask, why do they need to be out of the office? What's the reason? Is it that they're subject to an order of quarantine, which would be included in FFCRA reason? Or is it some other reason, right? Where the pandemic first happened, we saw a lot of employees saying, I just don't feel comfortable coming into the workplace. And comfort is not one of the reasons that's protected under FFCRA or New York State COVID. So if they are giving you an FFCRA related reason, you have to ask yourself, are we subject to FFCRA right now? Did we extend it? Were we subject to it? Are we subject to it now? Is the employee eligible for FFCRA? Did they already take it? If they did, well, first, let's see, if they didn't, then it's easy, right? Let's administer the FFCRA benefits. One, because you have the salary caps and you get the tax credit for it, which is a big benefit in comparison to New York State COVID, where you don't get the tax benefit for that. If the answer is no, so we elected to not continue FFCRA, or the employee has already taken FFCRA, then you have to ask yourself, is the employee subject to an order of quarantine or isolation? The answer is yes, it's New York State COVID paid sick leave. If the answer is no, then we have to look to see whether they have FMLA. So we go back to traditional leaves, or do we have to provide them with a reasonable accommodation? Other reasons, right, are if they have to take care of a family member, they get that for New York State paid family leave. So again, New York State paid family leave is generally not for an employee's own health condition, but it's to take care of somebody else. And if it's a non-FFCRA reason, if it's an employer mandate, if we're keeping them out of work now under that late January Department of Labor guidance, we have to pay them until we're either allowing them to come back or they are subject to an order of quarantine or isolation. Other than that, we look to see whether a reasonable accommodation has to be provided to the employee. I am going to switch it over to Rose to talk about how to really deal with this in the real world. And then we'll answer any questions at the end.
Thanks, Erin. And a couple of things about FSCRA. We're hearing that an employer can elect to just carry over the employee portion of and not the child care portion, that they can elect to separate the two. Is that correct?
I know that is a question. When I go back and I read what was actually enacted, it's not clear. And I would caution employers from picking and choosing the FFCRA benefits. I think you get into a really great gray area if you are picking and choosing.
Yeah, I agree.
Yeah, so I think it's better that if you're going to elect it, you elect it across the board for all the reasons and for all employees through the 31st.
And they only get to carry over if they used any in 2020. Don't they only get to carry over their remaining balance of FFCRA?
For FFCRA is you get one crack, right? You get up to 80 hours. under the emergency paid sick leave, and then up to 10 weeks for reasons related to childcare. The last week of 2020, I would have told you that New York State paid COVID leave was the same, that you get one crack, that you get either 5 days or 14 days. And that has clearly changed in the past 2 weeks.
Right, absolutely. Well, great. I'm sure everyone has more questions, so I'll get to my point. Can you all see my screen? It says the practical guide.
Yes, we can see your screen, Rose.
Wonderful. So now that we kind of Erin did a really great job, and I loved her graph because it's going to be really helpful. You should save that and use it because this stuff is so complicated and you have concurrent things going on. So it's not for the faint of heart. I have a whole team. We offer outsourced leave management, and this team is dedicated to this. And it's so complicated. So what do? You're going to manage yourself, and there's a lot of things you need to do. So the first thing you need to do, you saw in Erin's graphs and the laws, you understand where you fit in, like what size is your company. So always make those notes, which apply to you, and push off anything else that doesn't apply to you. So know your numbers, know where you put and how much leave you have to give. So leave policies and procedures. So the first thing you want to do, and as Erin mentioned, you have an election this year. You can elect to carry over. There's nothing in the law that says it, but for best practices, I would make note of the decision I made. Put it down, and I made this decision to carry FFCRA, or I did not elect to do it. And you're going to have to update your handbooks accordingly, because right now you have to modify the New York State COVID. You should already have that in your handbook. And you should also have had the FFCRA in your handbook from last year. I know in our handbooks, we did a pandemic supplement that covered things that may go away, like all about a pandemic and protocols, and the FFCRA we put in the supplement. We're hoping to burn that one of these days. When this is over, we can get rid of that supplement. But for now, you should have all the things that apply to your current conditions, more extensive remote workforce, that sort of thing. It's really important to educate your managers, especially if you've made these elections and which one you're going to go to. We're seeing so many managers not being told what the rights and responsibilities of their employees are. And for larger companies where they are out of sight and out of mind, they may be saying the wrong things to employees when they're asked. So please get your managers together and have a session about all of this. So, or just train them to ask someone that does know what they're talking about with leaves, because they can get the company in a lot of trouble. Everyone will probably tell you how much litigation is being currently done with employers that are either not giving the leave out to employees, or they're terminating while they had leaves, because this is job protected leave. So managers are really key to understanding these laws and helping you administer these forms of leave. You also want to, even the top needs to understand how this is all going to go, and they're not going to question why someone's out, or do they get this out again now that we have expanded New York COVID. So it has first time testing positive, second time testing positive, third time testing positive. They wonder why they're out. So you want to make sure that you educate everyone. You want to have a point person, because there are parts, the part payments, or when they've exhausted their benefits, that if they're still ill, if the employee is still ill, or if they're still taking care of a family member, you want to make sure you have your point person that is at your carrier of your DBL and PFL. It is very important that, you leverage them. They can help you make determinations. And a little different thing that is COVID related, when it's COVID related, there's not that elimination period. They get benefits from day one. Normally you have that week of elimination. So it's important to work with your carrier when you're exercising the when the employee is eligible for those benefits. You want to get together with, if payroll is not in the HR department, sometimes you find payrolls in the HR department and they're able to update everything. But if it's in the finance department or just a separate person does payroll, get together with that person. There's a coordination of the leaves with the payroll. When you've elected FFCRA, and last year, you want to make sure every time when a person's out on that form of leave, it was coded correctly. If it's not coded correctly, the employer does not get the tax credit. So someone has to communicate to payroll, this person has taken that form of leave. So they code it correctly. And as Erin mentioned, one of the advantages to exercising that leave is that the employer gets the wages reimbursed through the payroll taxes. But that can't happen if you're not in sync with the payroll. Determine if your payroll has the ability. We have the last October, we started with the New York sick and safe leave, and that has an accrual of 1 hour of sick leave for every 30 hours worked. So you're going to have to make sure that's another change in payroll, that there's a way to determine if you have seasonal or part-time, because this leave is all employees are eligible. Where paid time off, you normally have only full-time people. With sick leave, it's all people on your payroll get to earn this sick leave. So now you need a payroll that knows how to track that accrual. Consult your payroll provider, or maybe look for another payroll provider. I know a lot of small businesses use bare bones payroll, and this may be, I sound like I'm selling payroll, but I'm not. This is going to make your life easier if you get a payroll system that can do these things for you. You want to, especially many of these things can be done intermittently. So, again, you need to play a really automated way to track your absences. Notify your employees of their rights and responsibilities. This is another thing we're seeing, and it's very dangerous, is not telling all your employees about these laws, about their rights, about what their responsibilities to report to you. In any case, if you're subject to FMLA, a part of FMLA allows you to ask the reason they're out. There's a form of them filling in the determination, so you can make a determination. You still get to exercise that. And in the case of near COVID, with the second and third, maybe not for the first, because there's language that said you don't need to have prove that you're ill on the first, but the second and third only applies to the employees testing positive, and you do get to ask them to prove they tested positive in that second and third time. So that's an administrative thing that, why not? If you're allowed to, why not get that? Because unfortunately, we see a little bit of an abuse too. Notify your employees regarding the changes in the attendance and the payroll time off. That should be recorded, because a part of the sick leave is that employer's responsibility is to always have that record. And if an employee asks, that you would have that record of how much they earned. And you want to, if you don't have a formal HR department, you really need to either start thinking about having some sort of HR presence or determine who is going to be this point person, because this point person should be up on all the different leaves, how to administer it, and be available to answer employee questions. You want to develop your leave processes and prepare all the forms so you're able to administer this. Many of you want an initial request in writing. You want your response. Documentation is very important in all matters. Erin is smiling because documentation is a savior for an employer that you did the right things.
Yeah, we
And your
love
final
forms. We love documents. And I do think, Rose, I mean, we use a lot of forms or we help clients create forms for FFCRA. And we started with that because we thought it was helpful for tax credit purposes. But I also think it's helpful for COVID-19 leave as well, because it just helps you keep organized, right? And it requires the employee to make certain assertions, right? I mean, we like to have the employee certified that they haven't traveled outside of the scope. So yeah, I love forms.
I do too. And you nailed it. It keeps you keep all these straight, because one of the complicated parts about administering is to think of each one of these forms of leave on almost a separate timeline. And if there's document on each leave method, it helps you see what overlaps, what's running concurrently, what's not. This is complicated stuff. You need a system of operating to keep it all straight. And that's my next point about having a system to have track these timelines. So, what are they eligible for? How are you tracking this? I mean, payroll products are good. I say make a nice big spreadsheet and have each timeline. You want to know, you want to gather the information, hopefully have good information about what their current pool of time in paid sick time, whether you do vacation sick, a PTO system. As soon as a person is saying they need leave, you need to gather that information. Hopefully it's valid information. This is the time to clean up those things too, because they're invaluable in having, when things get exhausted and when they can use additional paid time off. You want to validate employees' paid leave balances. You want to, if the employer currently pays for an employee during the leave, you want to make decisions on benefits, because you do have some choices, especially if they're exhausted all their leaves and still sick. There are some choices you can do with benefits about converting into COBRA, and at what point do you convert them to COBRA? So there's lots of decisions you need to understand and be consistent, because fair and consistent is key to any employer actions, especially in leaves. You want to know what your policies are. You want to administer them consistently, regardless of who's taking the leave. They're all for the valid reasons. Not because one person's worked there for 30 years and another one just started. That's not a good criteria, right? You want to be fair and consistent. You want to track how the different forms of leave run concurrently, and which ones stack. What stacking means, one happened, then the next one happens after that. So in the case of FFCRA, they've exhausted it. The New York COVID leave kicks in, and because they tested positive a second time, so it's stacked. It comes after they've exhausted the FFCRA. hold on. Really strange. You want to develop your leave processes and prepare for the, oh, I'm sorry, that's the next one. My screen is frozen. I'm sorry, folks, my screen froze all of a sudden.
Rose, I'll try to pull it up on my side.
Yes, because for some reason I'm having an issue. I think my computer has COVID. Oh, I think I got it again. It came back. Okay. So some things you can do to mitigate risks. You want to communicate your new policies. Again, I can't stress this enough. We're seeing this. Managers don't know, employees don't know. You need to roll out these policies. You need to roll out the changes. You want to make sure you update your managers, even if
Uh-oh.
All right, I think we may have lost Rose. Erin, we want to answer a few of the questions?
Yeah, I think
and-
that's a good idea.
Okay.
I'm back. I'm sorry.
Oh.
I'm having issues. So
Rose, would you like me to run your PowerPoint from my side?
I think as long as it's working, I'll just continue. But if I lose it again, I'll certainly take you up on your offer.
Okay.
There are new posters. Make sure you have posters around your workplace if you're up and running and people are coming to work. You want to establish that point person for your insurance. You want to establish who's going to be responsible. You know, Erin and I just told you about the latest and greatest here. And you want to know, you know, who's the person that's going to be updating the new laws and updating your policies and your handbook. You should have a delivery of your handbook someplace where all the employees can see the updates. Again, going to payroll products, there's usually a place that you can post your handbook or use a shared drive. Try to gain an understanding of how these all interplay. When it comes to the employee's condition, you want to make sure that you increase the level of confidentiality and you have separate files in a locked place. You want to make sure you have a place to talk to employees about their intention to return to work, and you have that documented, and you have proof that you talk to them on the phone, email, the paperwork. You want to have a safe place where all that documentation is held, have only the right people looking at it. It's not able to be looked at by anyone. You want to have the ability, maybe hire an occupational health place or have a relationship with them. You know, if you want to clarify that they're eligible, if you are able to get proof that you have a mechanism, make sure that you have an ADA request, forms, approvals, denials. If you do need to have exercise accommodations. You want to make sure your job descriptions have all of their job essentials in there and clarifications on how people return back to work. And you want to make sure you leverage people like Aaron. If you have a questionable request about needing accommodation, if you do have to terminate employees that are on leave, and there are valid reasons. There could be that the company's decided, not all companies are, many companies are still struggling. So they may have to eliminate a whole department or downsize still. So there might be reasons, but I think when a person's had leave and you do have to terminate, you should always run that by legal counsel, because it's going to be extra sticky. And you want to make sure that you have your ducks in a row.
Rose, this is Jen. I'm running the PowerPoint on my side because your PowerPoint wasn't working, and we also can't see you. So if you want to tell me when to advance, I'm happy to do that for you.
Okay, I'm on administrative processes.
That's what we are too.
Okay. And I don't know why I can't see anyone, but determine how employees request the leave. So this is administrative side to it. Are you going to accept paper copies that go to HR? Are they going to go to a payroll portal? Are you going to phone, text, and email? We always recommend you have at least 2 different forms, because people get things differently, and the important piece here is that the employee does know that they have to request it, and that you have a mechanism to get all your pieces that you need.
Well, and Rose, that's so true. So just to jump in, so I had to take PFL last February, and I practice labor and employment law, and my job is to know New York State PFL. And there were ins and outs of it, and the forms were so confusing. And thank God I had a wonderful HR rep who was able to help me walk through the process. It is complicated. It's not easy. And I'm definitely one of those people where I need to both see things, read them, and also have somebody talk through them. So that's such great advice. And it was so helpful for me, even in my process.
I know. And Whiteman has the benefit of having a nice HR department. And
Yes.
The problem is with a lot of our businesses, it's the whole reason why we offer outsourced HR. We come across so many businesses that have little or no HR. And this is for the professionals, because this is very complex stuff and time consuming. I can't even begin to tell you how one case, well, we actually have a metric, one case, just one employee needing leave will probably take, just to get them out on leave and coordinate everything, 10 to 12 hours.
Wow.
It takes just to get through the case, the determinations, the forms, and then you're still left tracking the leave.
Yeah.
Right? So it's not easy stuff. You want to have all your timelines, so you have your documentation that follows the timelines. And when they go on unpaid, you want to make sure that you have a mechanism to exhaust their time off that they may have. It's to your advantage to have them use up their paid time if it's available. The hand-holding, as Aaron just mentioned, is underestimated too. Employees are very stressed. These are stressful times. It's not easy to tell your employee you've tested positive, right? Or have a family member. So you need a confidant. You need a person that the employees are able to go to and tell what's going on, and that person should have enough employee relations under their belt that they can handhold the person through and keep a constant dialogue so that you know how to track it. They have lots and lots of questions, and they're going to your managers, and the managers aren't great place for the employees to go, but they're frontline, right? They're going to go. So your managers should be sending the employee to the knowledgeable place that can answer their questions, because otherwise you're going to get different answers to different questions. We see it all the time. That person should be the person that tracks the leave from start to finish. It shouldn't be dissected into pieces. Like one person tracks the time off and another person does the paperwork. It really should be a point person, and they do the entire leave management so that they have a full understanding of the different timelines and what the employee gets and doesn't get. And I can go to the next slide. So asking questions and requesting medical documentation. So I always say start with the FML. If you are, if you're an employer that has FML, it allows you to do some things, and all the laws say that you still can carry on your normal leave practices. So that's a normal leave practice when you have that you can determine whether they have FML. And it also lets you have some groundwork for the other decisions, because you're gonna pull how much paid time off they have. You're going to give them the forms that are required. You're going to be able to see what questions you can ask. You should know the questions you cannot ask, because with FFCRA and the near COVID, there are certain questions you cannot ask. You want to have additional paperwork to make the determinations. Always send a piece of paper to the employee saying what they're eligible for. And are you following up with the employee? And because, again, to make things complicated, when it comes to the forms of leave, most you can count in hours, except for PFL and DBL. If they take any portion of the day, it's considered one full day of usage. So see how those two timelines can be very different. And next slide. So I did a little case study we can walk through, and that's how we can end it with just this case study. So we have a sales associate. She's feeling under the weather with flu-like symptoms. And so she goes to get tests. She tests positive. So she has to be quarantined. And this is her second time she's tested positive. And at this point in time, we looked her up and she has 5 days of PTO left. So next slide. So our steps. Are we an FML employer? Because if we are, we're going to start with her first day out of work, and that's the timeline for FML. We're going to, every hour that she's out of work, we're going to impact that timeline, because she gets to have up to 12 weeks. And if you use 40-hour days, that's so many hours of FML. So that clock starts ticking. Was medical documentation required for the FML purpose? So you want to gather that. And then you want to send the paperwork on whether they are denied or this person's been working there more hours and longer than a year. So we sent her paperwork saying that she is eligible for FML. So this is job guaranteed leave. That's why we want this timeline. And we're going to not collect hours that are not worked. I made this note that collecting hours not worked can be more difficult with your remote workforce. This has been a challenge in general with remote workers. How do you know when they're working and when they're not working? And especially for our non-exempt people that are paid, for the hours worked. And it's become even more important that we have a mechanism to track the hours actually not worked for the leave purposes. Next slide. You want to gather all the leave policies that you currently have, because some employers give extra benefits. Some employers give a lot of PTO. So you want to make sure you have that information, put it to the side. You may or may need to have that information. The PTO, in some instances, the 2/3 paid on the FFCRA, if they're tired, but they can work so many hours, they're on COVID leave, but they can work a little bit because they're feeling okay, but they tire easily, they can supplement their benefits that they get with DBL or PFL. Next slide. So I'm gathering all this information so I know what to do with this employee. So did I choose to continue FFCRA? Because that's going to allow me to know what to do with this person. How many days did they have left over? This is their second time she tested positive. So she may have only 5 days left of FFCRA. So I will count her first 5 days and I will code it properly in the payroll so I get those reimbursed. But she's going to be out more than the 5 days. So I'm going to have her take her New Year COVID next, because she gets 5 days, because that's my employer size giving her 5 days. Next slide. So that's what I say in this first paragraph, that she's going to get 5 more additional days. So now I have the timeline for, I've exhausted my timeline she had for FFCRA, because I had that timeline saying she had 5 days, and I'm checking them off. And then now I'm checking off her New Year COVID leave. That's given her a second time of 5 days. And I'm also going to send her a piece of paper saying I need proof that you were tested positive. And if her benefit is, if her pay is less than her full wages, I'm going to send her any paperwork. And you can actually just send this at any time and saying, because the forms reside with you, you have the insurance carriers forms. Make sure that the employee knows where those forms are, because it's the employee themselves that has to submit for the DBL or the PFL. Next slide. So here's where you finally sit down with Karen and you go through and you communicate what type of leave, all the different timelines. At one point, would she exhaust all her benefits if she's still ill? What would happen when? And you kind of walk her through her different timelines. And you tell her where her claim benefits forms can be, that she has to submit them if she needs to.
Hey, Rose, we got this question a lot in the chat as to when does PTO come into play with other leaves? And I think you're addressing that right now. So we should probably just walk through it if that works for you.
Absolutely, absolutely.
For
Yes.
FFCRA, right, the step one of FFCRA is at 80 hours, the emergency paid sick leave. And what the statute says, what the CARES Act says for that is that you can't charge an employee's paid time off accruals, right? This is like a freebie. And it's a freebie because the federal government says you're getting the tax credit for it. So you can't charge anything for them if they're getting their full rate of pay because they're the ones that need the emergency paid sick leave. What Rose was saying too, indicating is if they need that 80 hours to take care of somebody, so whether it be somebody who's on an order of quarantine or because daycare, school is closed, they get their 2/3 rate of pay, right, under the statute. And so for that first 80 hours, you, the employer, can be generous, right, and say, we will allow you to supplement your paid time off accruals so that you get 100% of pay during this time period. There are positives and negatives to doing that, right? I mean, it is more money out of pocket that you're not going to be able to claim the tax credit for. But then you're also having your employee work their accruals down. So it's not going to be the instance where they're out 2 weeks, for COVID related reasons, and then still have their summer vacation. So it's really, in terms of operations, it's an operational decision, whether you want an employee to have that. It's my understanding you cannot require, though, an employee to use their pay time off accruals for that first FFCRA period. Once we get into step 2, which is the emergency extension of the FMLA, again, that's only for people that have to take time off because of daycare and child related reasons. You treat it like you normally do with FMLA. And so if your FMLA policy is that you have to use your paid time off concurrently, you do that, right? And so it's not dollar for dollar during that period, but it's the supplement. So it's that 1/3 of the PTO for that 10-week period. For New York State paid COVID leave, Rose, it's pretty clear. You can't charge an employee's paid time off accruals.
No, not if they're eligible for the days under New York COVID.
Right. You can't charge their paid time off accruals. You cannot charge their New York State paid sick and safe leave, although, right, it's pretty clear they're sick. But this is time in addition to the time the employee already has under your policies and the law. Rose, we got this question, which I thought was really interesting, which that point 3 on the Department of Labor guidance about,
Yep.
I'm mandating you to stay out. You don't have an order, but I'm telling you to stay out and now I have to pay you. Whether you can charge an employee's accruals or not.
It's not covered. Yeah.
I don't think you can. And it's not.
I would tend to think not because of how strong the language is in every other part of it, but it is unclear.
Right. It's very unclear. For sure, you wouldn't be able to charge their New York State paid sick and safe leave because you're mandating them to stay out, right? They're not the ones coming to you and saying, I'm sick, I can't come in. But it is unclear about the paid time off accruals for sure.
But it kind of helps to think of it as you would have your COVID leave. They exhaust the COVID leave because people, some individuals are sick for a long time.
Yeah.
So they could go exhaust FICRA. They could exhaust the New York COVID. Then if they themselves or their family member is actually sick, it's not a precautionary, but they're still sick, say they're in the hospital, they would be able to exercise their sick leave pool, whatever their accrual was at the time. And then when that's exhausted, then they would have their PTO. That's normally the way the sequence would go.
Yeah. And the alarming thing about the Department of Labor guidance, that point 3 that we were talking about too, is that, and I don't know, honestly, I don't know how big of a deal this will ultimately be. I don't want to be kind of the lawyer screaming fire, right? If in actuality, it's not going to have that big of an impact. But the circumstances that have come up since that guidance have come out is like bad actors, so to speak. So people who everybody knows flout social distancing rules, you know, they're on Facebook, you know that they're at events. And so your coworkers, right, your other employees, they don't feel safe having that person in the workplace. It used to be the case, right, where you could tell them to stay home. And if they were a non-exempt employee, it would be unpaid. Now you have to pay them. So it is almost rewarding bad behavior, right? And I know that is one concern that we're hearing with that. And so I know a lot of employers hope that some guidance will come out saying, in that instance, if I'm mandating you to stay home because of your own actions, I get to charge your paid time off accruals. We're just not there yet. We don't have that information.
Right. And it probably, it doesn't hurt to emphasize this again. If the employee is able to work remotely and they have the ability, you're not forcing them, because that's another situation, you know, you're not making them work while they're ill, because that happens. But they've agreed, they say, I can work, then they don't get these leaves, right? They're
Right.
only if they're not able to work.
Right. Yeah, I think that's exactly it.
Next slide. Okay, so now it's question time, and I did put a resource into, there was a Q&A from the CDC that was really helpful to employers that answered a lot of questions about COVID leave. And the DOL has a nice new Q&A too. But Aaron and I are available for questions now.
Well, and Rose, I have some up. Why don't I read some and we can go through them? So we talked about the use of paid time off accruals. Another question that we got is Department of Health is so far behind that if you call DOH, they just say the person should quarantine, an employee doesn't get an order in writing. So it's my understanding that the process is that you contact the local Department of Health and they are required, whether this actually happens or not, they are required to issue an order within 30 days of being contacted. And so kind of what happens in between, right? I mean, the person is going to need to be out, you're going to need to pay them. What I like to do is to use a form, and on the form, you know, ask for a certification that you've been told by the Department of Health to quarantine. Or alternatively, what an employee has to do to get PFL benefits is, in the absence of that order, get a doctor's attestation, essentially saying that this person will be eligible for an order of quarantine. I think employers should give the leave, right, with kind of the asterisks of, we're going to need this documentation from you when you get it. And the failure to provide it, right, could be a source of discipline if it ultimately happens where the employee didn't ever get that. But I think that's kind of the documentation that you ask for in the interim before the Department of Health ultimately issues the order.
Right. Also, we know for a fact that if they've been tested, they're going to be getting from the Department of Health the tracking, a text every day or an email every day. You have your choice.
Right.
And that would suffice, that because it states on there that you're under quarantine for a certain period. So any of those forms of proof, if the employee says there is no proof, that would be suspect.
Right.
Because there's a lot of things that are happening when you test positive.
Yeah. exactly. Another question that we got is, let's see. Oh, sorry. How does this impact key employee provisions of the FMLA? There are no key employee exemptions to FFCRA or New York State paid COVID leave. So it's an employee is an employee for purposes of those paid leave. That's your understanding as well, Rose?
That's correct. That's the kind of the only difference.
Right. Another question is, our full-time week is 35 hours. Do we still need to provide 40 hours of paid sick leave, or is 35 okay? Do you want to answer that, Rose?
Yeah, if they're talking about the New York sick and safe leave, I'm guessing that's what, it's not based on how many hours that you're calling full-time. You have to record 1 hour that they earned of sick leave for every 30 hours worked. So it's not going to sync up with the way you call full-time. It's every 30 hours, and because that's even part-time and seasonal people. Part-timers that may only work 15 or 20 hours a week, they're going to earn their sick leave at a much more slower rate than one that works 35 hours. But you need a mechanism that counts every 30 hours that they get in their pool, 1 hour of sick leave.
Right. And for COVID related leave, right? FFCRA or New York State paid COVID. It's not that the employee gets 14 days, right? If you're a large employer of pay. What the employee gets is whatever they would have been entitled to had they worked during that 5 or 14-day period. It's the same thing with New York State paid COVID leave. It's not an automatic award of 5 days of pay. It is whatever the employee would have been paid during that time period. One question that and this may be the last question that we got is, when would we elect FFCRA? And I thought that was interesting. I mean, right now, and Rose, again, I think this is more as to what works best for your workplace. The FFCRA provides much more generous benefits to employees in terms of the reasons which they can be out of work. So it's not that they just have an order of quarantine, right? It's that they have COVID-19 symptoms and are seeking a medical diagnosis. I have a runny nose right now, right? If I am nervous and I'm thinking, I haven't left my house in 2 weeks, but I'm nervous, I need to go get a test. And the test I don't get a test until next Tuesday, right? I could be eligible for FFCRA. I mean, it's that broad. Mm-hmm. As compared to New York State, where you need that order of quarantine. The benefit of going with FFCRA first right now, and again, because FFCRA is stacked with New York State paid COVID leave, is you get the tax credit. And so it really is a very individualized decision that you're going to want to talk to. And we're at February right now too, right? I mean, if you're getting your first case of COVID in 2021 now, you're doing pretty well. Yeah. But really, you would have already had to make this decision a month ago about whether you've elected to continue it or not.
Right. Officially, you should have made this decision January 1 because it officially ended December 31st.
Right.
So going into the new year, You should have made the decision which one you're going to elect, but it's still not, if you haven't had a reason, you can still go with FFCRA. And it's really like Erin had described, it's weighing the two things. What's more important? Is it more important that I don't really care about how many days that they have because I'm going to get those wages reimbursed? Or I really want to limit this to only certain reasons. Like if they go to Florida, I don't want to have to pay them for that quarantine.
And that's a good point, because if they do go to Disney World, they still get FFCRA. There's no travel ban essentially, right, on those benefits. Yeah.
But you get the wages reimbursed. So this really like, what's more important to me, having the wages reimbursed or telling the person they have to come to work or they use their own paid time? Because that's not going to be that's not going to be New York sick leave. They weren't sick. That's going to be a PTO event.
Yeah. So Jen, I want to be mindful that that's 10:15.
So it is 10:15. So I think what we'll do is we'll stop here. I will be sending out the slides and the recording of today's program. Rose, you had mentioned a few links. Can you send those to me and I'll forward them on to everyone? Wonderful.
Yep, the CDC and the DOL links I'll send.
Wonderful. Wonderful. Well, thank you, Rose. Thank you, Erin, for sharing these updates. Great information once again. Thanks to everyone that participated this morning, and please look for the information later today. Thanks so much. Everyone stay safe and enjoy the rest of your day.
Thank you, everyone.
Bye.
Stay safe.
Thank you so much.